Firstly, I would like to talk about debt per se. I mean, what debt in general means. Uh, in simple words, debt means any liability, means anything that you have to claim, take, or ask for from any organization, be it your company, be it a company or a financial institution, or any activity which is arising out of business transaction. Basically, you did business and you have to take money, or you that's ideally. Now the next question that comes into mind is what kind of business. So to that, I would like to say that business basically means a activity which is legally valid in law. So for example, I say that okay, I'll pay you 50,000 rupees. You do an activity like, say, stealing some goods, or something of that sort. That's not a legally right business activity. That's not legally permissible business activity. So you cannot claim that amount as debt, even if the other party does that kind of a work. And if you want to go and recover, no. So in simple words, in simple, very, very, because today's presentation, I mean, I personally feel it's going to be from a perspective from law students, or people who are not from legal background, business owners, or someone who will actually relate that what the debt is. And I want to give a bird's eye view on what the entire process is all about, how it goes about, and what things you have to keep in mind to ensure that you are legally correct. So it's just an awareness that I'm trying to spread through this presentation. So this is what is a debt, the meaning of debt in very simple words. Then the question is when it's debt recoverable. So now this is a very interesting aspect. So like today I lend a money, and then can I recover the money tomorrow itself? So when is it recoverable? So first thing is, it has to be a transaction, a business transaction which is valid in law. First thing is that the debt that you are claiming for has to be arising from a transaction which is very, very legally valid in law. Second thing is, it should not be barred by time. Now there is a act called Limitation Act. So if you want to recover your debt, then it has to be a time frame within which there are laws which clearly say that what debt is cleared, recoverable by what time. So the transaction has to be falling within that period of time. The debt has to be falling within that parameters. Then you can claim. So like suppose today I give a money, I sleep for it for 10 good years, 12 good years, and then one fine day I wake up and say that I have to recover the money from you, give me. You cannot recover it in that way. It has to be legally falling within the limitation. Then who is a debt is recoverable from whom? It can be individual, it can be a firm, it can be companies, it can be financial institutions, or it can be any natural or juridic person. But it cannot be a minor. So suppose I give money to say 16-year-old or a 14-year-old, and I say that no, I paid you, we executed a contract, we did everything, so now you paid back. No, it cannot be with a minor. So the idea of sharing this is to get to create to share a knowledge on the point that these are the people with whom you can and cannot do any kind of transaction. So while lending your money, so for example, in a business transaction, it many times happens that okay, my friend wants money, he told me that you transfer the money in account of his minor son. I transferred it and now my friend is not paying. So now legally you cannot, because he's a minor. I mean, and he's and your very transaction is not void in law. So then the idea of sharing this point is to create a caution that okay, these are the points that I have to consider while lending it. Now chalo, debt is given, now the debt has arisen, you gave the money. Now how do I recover? So I'll try to give you an idea that debt can be recoverable in many, many ways. So there are some remedies which are of civil nature, some remedies which are of criminal or punitive or punitive, as you say, nature. So ideally, at times you can take a combination or you can take one remedy. So what is civil remedy? Civil remedy basically means a remedy by which you are actually going to the court, asking the court to direct the debtee to pay you the money to recover your debt. So that's one process that you do for recovery of money. So now what kind of suit I should file or what it happens? So basically you can file money suit, commercial suit or summary suit. Now basically I'll not go very technical, but suit means a kind of a suit is a claim that you're putting up before the court of law. So for money, you are saying that I did so and so business transaction. This is the debt arisen. He has not repaid it. Kindly pay him. Ask him to pay. So that's money suit that you're putting. If it's a commercial, there is a Commercial Courts Act which has come up, so which provides a specific provision for commercial suit. So you're filing a commercial suit there, or a summary suit that you're filing like when the other party accepts the claim. And many a times it so happens that in a business transaction the other party says, okay, give me 15 days time, I'll repay, or the debt is very much acceptable in black and white. In such kind of case, we put up a suit saying the court that, see, now the debt is admitted, so a decree may be drawn on the basis of the admission they made. In such case, the defendant, that is the person who owes money, who owes to repay the money, has to really justify and give a bona fide reason before the court as to why is he entitled to defend. He has to take permission to defend the case. So these are the three kinds of remedies that we put up before the court in a civil, normally in a civil perspective. Now, what are the points to be considered while you are dealing with a particular suit, whether the debt is operative or is it by time barred? So like normally there is a period of 3 years. Obviously it varies on case to case and circumstances to circumstances, but ideally 3 years is a period for which you can recover your debt. So are you falling within that 3 years? Is the last payment made within 3 years, or is the part payment made within the period of 3 years, or is the debt admitted within the period of 3 years? So that is one parameter which is normally looked up to fit in that, okay, my claim is not time barred. Second thing, so that's the point. As an individual, you have to assure that, okay, it's not too long, my debt is not too long, so that let me take up the legal recourse if at all you wish to. Second thing is whether it's a legal transaction or an illegal, which I already discussed, whether it's a valid transaction, whether the other side has disputed or undisputed, whether the debt is disputed. Like for example, many times the defendant do say that no, this is not the claim that I have to pay, I have never received any kind of money, there's nothing. So if it's a disputed one, or is it a undisputed one? So those things are to be taken care of. And what are the evidences that you have in hand, or circumstantial or electronic? So this is a very, very interesting and a vast topic in itself. Evidence means what are the documents on the basis, or what are the evidences on the basis you are claiming that this is a debt that I owe. So basically in court of law, the burden of proof is always on the plaintiff, that is the person who is making the claim. So if I say this is a debt that I want to recover, then I have to come with documentary evidences or electronic evidences or circumstantial evidences which explicitly make out my case that yes, this is the amount I owe pursuant to this transaction. So for example, business transaction, so then you may have your bills, you may have your challans, you may have mails exchange, which is again an electronic evidences. You have everything and there is no dispute. Basically the other side has, if there is a contract, of course contract, so basically it clarifies, okay, this was a transaction, this is the money paid, and this is not the money which was ideally to be paid within this stipulated period. It is flouted willfully and hence the claim arose. As simple as that. And interest. Now to claim interest, ideally in summary suits, in other suits you can claim, but in some forums it is you can claim interest only if it is mentioned is either in your bills or in your contract. It is explicitly agreed that what will be the rate of interest and what will be the uh, interest, how will it will be charged. So those are the points which are to be taken care of. So like, how is it going to be useful for you? So if you are a businessman or if you are a person who is lending money, you have to ensure that you have all these things in place. Is your interest clause in place? Is your documentary evidences and all kinds of communication in place? Whether the debt is within the parameters of time frame stipulated, all those parameters have to be considered before proceeding in a court of law.